Ready, start. While appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to be truthful in the given circumstances of the case. Full stop. Once that impression is formed, it is necessary for the court to scrutinize the evidence more particularly, keeping in the view the drawbacks and infirmities pointed out in the evidence and evaluate them to find out whether it is against the general tenor of the prosecution's case. Jivan Lal is the son of the deceased Meena Devi residing with her and the accused in the same house and a natural witness to speak about the occurrence. Full stop. Evidence of PW1 is a cogent and nature and is a consistent with the prosecution case. Full stop. The High Court was not right in doubting the evidence of PW1 on the ground of alleged improvements made by Jivan Lal and rejecting his evidence on the premises that there were certain improvements. Full stop. As pointed out by the session judge, deceased Meena Devi was last seen alive in the company of accused Rajkumar, and the accused did not satisfactorily explain the missing of deceased Meena Devi, and the same is a strong militating circumstances against the accused. Full stop. Meena Devi, who was residing in the same house with the accused and last seen alive with the accused, it is for him to explain how the deceased died. Full stop. The accused has no reasonable explanation as how the body of Meena Devi was found hanging from the tree. Full stop. As held in Kashiram case, it is for the accused to explain as to what happened to the deceased. Full stop. If the accused does not throw light on the fact which is within his knowledge, his failure to offer any explanation would be a strong militating circumstances against him. Full stop. Para, as pointed out earlier in his questioning under section 313 CRPC, the accused simply denied the evidence of incriminating circumstances put to him and pleaded that he is innocent. Full stop. A feeble attempt was made by the defense to suggest that the Dickies consumed poison and committed suicide. Full stop. Viscera of Dickies Meena Devi was sent, and as per the FSL report, no poison was detected in the viscera of the Dickies. Full stop. In our considered views, the trial court rightly rejected the plea suggested by the defense. Full stop. As pointed out earlier, in a catena of judgments, this court held that when conviction is based on the circumstantial evidence, there should not be any gap in the chain of circumstances. The accused is entitled to the benefits of doubt. Full stop. The circumstances upon by the prosecution are proved by cogent and the evidence. Full stop. The circumstances cumulatives taken from a complete chain pointing out that the murder was committed by the accused and none else. Full stop. In the appeal, the High Court has not properly appreciated the evidence and the worth of the testimony of the prosecution witness and the formidable circumstances established by the prosecution against the accused. Full stop. The High Court entertained fanciful doubt and the rejected the credible evidence of Jivanlal on the slender grounds. Full stop.